All right, over to you, Sarah, for the intro.
Great, thanks, Abby. Hi, everyone. Welcome to our webinar today on restrictions for government contractors on hiring former government employees. My name is Sara Ryan. I joined the Labor and Employment Law Group here at the firm back in April of 2025. Before that time, I had a 15-year career in the federal government doing employment law, ethics, ad law, that kind of thing. So very happy to see some familiar faces here today, and we're excited to talk to you about this very important topic. Before I allow Abby to introduce herself, I wanted to just give you a little bit of an overview of how today is going to go. We are talking about, very dense, very complicated federal statutes and regulations on the procurement side, on the criminal ethics side. We cannot get into every detail today. And the purpose of the presentation is really just to give you a broad overview so you can spot these issues and really know when to phone a friend when you think that you might be dealing with one of these post-government ethics restrictions. So Abby, over to you.
Thanks, Sarah. I appreciate that intro. And just like Sarah, although my career in the federal government wasn't quite as long as Sarah, I did come to the firm with some experience in the federal government world. So I worked for the Naval Sea Systems Command headquarters in the Office of the General Counsel there. So as another formal federal government employee, pretty well versed in being able to navigate the restrictions placed on current and formal federal government employees as they make the shift to the private sector, and being able to offer some good insights for you all today. So I'm an associate in the government contracts practice group, and I pretty commonly deal with organizational conflict of interest issues and Procurement Integrity Act issues that we'll be discussing today. So all of the things that we'll be talking about today, Sara and I both deal with on pretty much a day-to-day basis here, and there'll be a lot of overlap between our practice groups. All right, so about PilieroMazza, as I said, I worked in the government contracts group at PilieroMazza, and that's one of several practice groups that we have here at the firm, including labor and employment, which is what Sara supports. We also have a business and transactions practice group, litigation and dispute resolution groups, as well as a number of practice groups that deal with some more nuanced issues under those pretty broad umbrellas. So as you can see, we're a full service firm that handles a wide variety of issues that impact government contractors. And like many of the issues that we help our clients address, what we'll be discussing today has some level of crossover between our different practice groups. So like I said, I'm in the government contracts practice group, Sara's in labor and employment, and our firm deals with a lot of issues that has some overlap there. So if you're interested in staying up to date on recent developments impacting government contractors, as well as just commercial businesses in general, you can sign up for our newsletters and blogs at this QR code here at the bottom of the screen. And with that, I will pass it over to Sara for the overview today.
Great. So an hour is a very short amount of time to talk about all of these dense laws, but we are planning to first hit the Procurement Integrity Act, then get into 18 USC 207, which is a criminal conflict of interest statute that applies to former government employees. We're also going to talk about a couple of statutes that impact current government employees. We're not seeing quite as many of those issues come up since the deferred resignation program has ended, but it is important to understand those rules as well. We're going to go through some real world examples that Abby and I have seen in our practice here at the firm or in our former government lives. And then we're going to close with some compliance tips on how you can improve your best practices to make sure that you don't violate any of these key laws. Abby, back to you.
Appreciate that, Sarah. All right, so like Sarah just went over in the overview slide here, here's kind of all the relevant authorities that we'll be discussing today. So we don't really plan to spend too much time on this slide. This is just to kind of give you a touchstone point to look at the actual statutes and regulations that we'll be discussing. So I'll be discussing the Procurement Integrity Act. It's also referred to colloquially as the PIA, and that's going to be found at 41 USC 2102 through 2105. Sara will then walk through everything to consider under Section 207. So again, that's kind of a shorthand version of referring to 18 USC 207. And as Sarah's walking through the Section 207 slides, she's going to hand it back to me for some of the more procurement specific elements of this section. You know, like we went over on an earlier slide, there's so much crossover here between these statutes and regulations between practice groups. So then those are going to be kind of our two big statutes that we'll be discussing today. We'll spend a large portion of the presentation there. Then we're going to go into some other considerations. So Sarah's going to touch on 18 USC 203 and 205, which are relevant to current federal employees. I'm going to walk through the FAR clauses on the screen there, which 52203-13. That's the covenant against contingent payments. Or I'm sorry, FAR 52203-5 is the covenant against contingent payments. 203-13 is the contractor code of business ethics, which includes a mandatory disclosure rule. And then FAR 3.101-1 prohibits certain conflict of interest. Then Sarah's going to get into some specific, like agency-specific regulations and Office of Government Ethics opinions. And with that, we will get into the meat of it here. So we're going to start off with the Procurement Integrity Act. So the first statute here is 41 USC 2102. So the prohibition here is two-prong, and it's applicable to both current or former federal government employees. So a former or government employee cannot knowingly disclose contractor bid or proposal information or source selection information. So the first part here is going to be this knowingly disclose element. And employee here under 2102 can be a little bit tricky because it refers to what you would think of as a federal government employee, but there's also kind of a nuanced piece of this where an employee can also be an employee of a private sector organization that's assigned to an agency specifically under Chapter 7 of Title 35. We won't get too much into it because if you are one of those employees, you will know. So the not knowingly disclose applies to both current or former government employees, which can include this small exception for an information technology exchange program. But then the second piece of this prohibition here is going to be applicable to everyone. So that includes both present or former government employees. It also includes you as a contractor. So the person piece of this here can be an entity, a contractor, as a person, or it can be, you know, an individual person that's working for a contractor as well. So the second piece of 2102 here prohibits a person from knowingly obtaining the same kind of information, so that contractor bid or proposal information or source selection information. So this provision can be pretty broad and can, for example, include information that a former government employee knows about other companies that, if disclosed, could provide your company with an unlawful competitive advantage. So in that instance, it would be both, the employee that's disclosing as well as you who's knowingly receiving the information that would be prohibited here. We also want to note that both prohibitions are before the award of a federal agency procurement contract to which the information actually relates. And we'll touch on this a little bit more later, but the disclosure of stale information isn't actually prohibited. But in order to determine whether information is stale or not, whether it's actually competitively useful, the government would have to conduct an analysis to determine whether there was or wasn't a PIA violation. So just because information is older doesn't necessarily mean it's stale if the information still remains competitively useful. So 2102, when most people think of the Procurement Integrity Act, this is going to be the touchstone statute here. This is going to be what you're thinking of in regards to not knowingly disclosing or obtaining competitively useful information. We're going to get into some other pieces of the PIA on the next few slides as well that are just as relevant and just as important, but this is going to be the big one here, 2102, that most people are probably already aware of. So 2103, what does this prohibit? So this is really relevant to current federal government employees. So if you are in employment negotiations with somebody, this is the statute that you should come back to here, because it prohibits a federal government employee from personally and substantially participating in a procurement if in employment negotiations with an offeror in said procurement. So there's quite a few different elements to this prohibition here. So, what does personally and substantially participate mean? How do you actually define procurement? What's an employment negotiation? How do we define all those things? So personally and substantially, let's actually touch on what a procurement is first. So it's important to note here that procurement doesn't just mean a solicitation is out on the streets. So, sometimes you think procurement and you think a solicitation's been released. We're at the stage where industry is getting involved and either submitting proposals, or maybe the government is in the evaluation stage. And that certainly does. That is certainly a procurement. But the clock actually starts ticking much earlier. So a government employee can be found to have personally and substantially participated in a procurement if they're at the requirements development stage. So it's not just applicable to contracting personnel. If you're thinking about hiring somebody who's a current program manager that might be helping to actually develop the requirements for a solicitation that you might bid on, that's where you should throw a flag up here and think 2103 might be applicable for me here. So a recent example of this, in 2024, the Court of Federal Claims found that the Navy reasonably eliminated a bidder from procurement due to the bidder's employment of a retired Navy expert that gave rise to an appearance of impropriety. So in that case, while still employed at the Navy, the person who was then hired by Raytheon was actually developing the requirements and participating in source selection planning meetings while in employment talks with Raytheon, who is a prospective bidder. So personally and substantially, that comes up quite a few times during our presentation today. And that really just means, it's more than just being one of 20 people in a meeting. You're helping to really drive the train here. You're making decisions on requirements. You are the contracting officer that's making decisions on, how evaluation factors are going to be written in the solicitation, things like that. Not just, you're on a team of 30 people and this solicitation is under the specific program that you work for. That doesn't qualify as personally and substantially participating. So there's a lot of very fact-specific pieces here. So, if a current federal government employee is personally and substantially participating in a procurement, that doesn't mean that you can't be in employment talks with them. There's just steps that you have to take in order to do everything by the book there. So if the federal government employee is contacted by a bidder or offeror, or a prospective bidder or offeror, if the world is small there in companies that really have the capabilities to perform certain work, that government employee is required to report that contact to their supervisor as well as their designated ethics official, and either reject the possibility of employment or disqualify himself or herself from further participation in the procurement. So one or two of those things has to be done, and your responsibility as the contractor is just to make sure that this government employee is doing those things on their end, or at least doing the due diligence on your end to have your record set to show that you did request that they, go through these steps here at 2103. All right, so 2104. This one is in relation to former government employees. So this has to do with a contractor's ability to offer compensation. So federal government employees who worked on a contract in excess of $10 million cannot accept compensation from that contractor within 1 year after the employee. And then 1 and 2 here are specific duties or specific positions that the former employee can't have served on a contract that you as the contractor worked on. So if you're thinking about hiring the contracting officer, the program manager, deputy program manager, somebody who served as the source selection authority for the award of your contract, like any of those positions, and your contract was over 10 million, there's going to be a 1-year ban there on employing that person, offering them compensation. And then factor 3 can be a little more fact specific. So we're happy to work with you here on an individualized analysis if that's going to be applicable. So if you're seeking to contract with individuals who served on one of those roles, or in 1 and 2, or served or um, not served on one of the roles in 1 and, oops, sorry about that. But in factor 3, because those have to do more with responsibilities rather than the roles themselves, if somebody had that responsibility for one of your contracts, then you're going to be prohibited from offering compensation there. So during that 1-year ban, you as the contractor can't knowingly provide these covered former employees with any compensation in any form. And I know I said factor 3 is the more fact specific one, but Sara and I have also worked on situations where we had to do an analysis for a person that maybe didn't necessarily have one of the titles, but possibly had some overlapping roles with a program manager position or a contracting officer position that's prohibited in 1 and 2. So they can be fairly fact specific as well, just like all of these statutes here. Okay. So what are the penalties for the PIA? So they're divided into 3 buckets here. The criminal penalties, that's only for a violation of 2102. So that's going to be the, knowing disclosure or knowing receipt of procurement sensitive information. And that's going to be the criminal penalties there will be fined under Title 18, imprisoned for not more than 5 years, or both. And then civil and administrative penalties are applicable to all 3 rules here. So the civil penalties can be, up to $50,000 for each violation for the individual, plus twice the amount of compensation received or offered for that prohibited contract. And then for the contractor, it's significantly more. So that's going to be up to $500,000 for each violation, plus, again, twice the amount of compensation received or offered for that prohibited conduct. There's also going to be administrative penalties as well. So that is relevant to the employee, adverse personnel action, as relevant to you as the contractor. The government can cancel the procurement if they haven't yet made an award, rescind a contract, or undergo suspension or debarment procedures. So there's, a lot of negative impacts that can happen for the violation of one of the PIA statutes. So now that we've gone over broad strokes there, I'm going to turn it over to Sara for the Section 207 overview.
Great, thanks, Abby. So the interesting thing about 18 USC 207 is that unlike the PIA, it never prevents a former government official from taking a particular job or accepting compensation from a particular contractor. Instead, what it does is it limits the type of work that a former government employee can perform when it's accepting compensation or representing or doing work on behalf of another entity. And so when you're thinking about 18 USC 207, again, this is the one that applies to former officials. There's 3 main provisions of this law that we're going to talk about today, and they apply under slightly different circumstances, and they also have slightly different restrictions on what the former officials can and can't do. So the first restriction that we're going to talk about is one that prohibits a former government official from representing back to the government about a specific matter for the lifetime of the matter. We're going to get into the details about what that means, but it's about a particular project or thing that they worked on at the government, and they are forever barred from representing back to the government about that. And we're going to talk through what all these definitions are. But then there's another part of 18 USC 207 that has only a 2-year representation back ban, and that is for work pending under someone's official authority. So even if you didn't necessarily work on it, but one of your subordinates worked on it, or one of your subordinates 15 levels below you worked on it, you're still going to have restrictions on your ability to talk to the government about that matter for 2 years. And then the third provision we're going to talk about today is a 1-year cooling off period for certain highly paid government officials that prevents those officials from talking to their former agency about anything for an entire year, really. And so 18 USC is important. It's scary, right? It's a criminal statute. There are potential criminal fines and jail time available as potential penalties for violating any of these provisions. There's also civil penalties for potential fines or injunctive relief. If you are someone who values having a security clearance, certainly violating this provision could impact your ability to be a security clearance holder in the future. And so 18 USC is very important, but again, it doesn't prevent you from working in any particular place. And for you all who are government contractors, it doesn't prevent you from hiring a particular person. It just prevents them from being able to have certain communications with the government while they are representing you. Next slide, please, Abby. Great, thank you. Okay, so the first one we are going to talk about is that lifetime ban. And when we're looking at 207, this is all about communicating to the government. This statute does not prevent individuals from doing work behind the scenes. This is all about communications to the government. Now, of course, there's restrictions on what you can do behind the scenes in terms of not being able to share, procurement sensitive information or other types of sensitive information, like classified information that you would have gained while the person was a federal employee. But really, the focus of these statutes is on communications to the government. So under this first one that we're going to talk about, 207A1, which is the lifetime ban, this prohibits former U.S. government officials. It also applies to D.C. government officials, but we're just going to focus on the executive branch today because that's the type of issues that we see most frequently in our practice. So former executive branch employees cannot represent back, meaning they cannot communicate to the government with an intent to influence about a particular matter, which is a specific thing like a contract or an investigation or a court case or something like that. If during the course of their government employment, at any time in their government employment, that former employee participated personally and substantially in that matter, right? Whoa, that is like a mouthful, right? There are so many different elements of this test that have to be met for this ban to apply. And that's a good thing when you're trying to comply, right? Because it means that you have to only meet certain criteria to not be able to have these conversations with the government about these particular matters. So again, we're just going to do a high-level overview of these very intricate statutes. But when we're talking about the lifetime representation back ban about particular matters, you have to have a communication. That communication can be in a physical meeting. It can be a written letter that you sign. It can be a phone call. It can be an email, right? There's all kinds of ways in our modern world that we could communicate to or appear before the government. You have to make that communication on behalf of someone. In this case, it's usually your new employer who's a government contractor. And, making a representation or a communication on behalf of someone, if you have an employment relationship with them or if you're an agent for them in some way through a contractual agreement or something like that, it's going to be a pretty low bar, right? Like I would probably not pass the smell test if I say, oh, well, I work for company B and I'm going to go talk to the government about a procurement that company B is interested in, but it's really just my own personal interest in this procurement, right? It has nothing to do with my employer that also happens to have an interest in company B. So again, to be talking to the government on behalf of someone else, it's a pretty low bar. It's really any kind of communication with the government, with the exception of some very tiny type of factual communications that we'll get into, with an intent to influence. And again, the bar for intent to influence is incredibly low. It's broadly interpreted. When you look at the regulation and you see the things that are excluded from intent to influence, it's something like you can sign a tax return if you're the treasurer for a nonprofit or something, and you're going to sign the tax return that's going to go to the IRS, right? Or you can sign acknowledging receipt of a piece of mail that came to your company, or you can answer just totally neutral, fact-specific questions about something when asked by the government. Those are sort of the very narrow types of communications that don't have the intent to influence. Okay, what about social situations? Just really quick before we head to the next slide. Um, can you potentially communicate with the government, with your former agency, with an intent to impact in a social situation? Well, it really just depends on what the nature of the conversation is, right? If I'm going to a retirement party for somebody that I used to work with at USAID, and I just so happen to work for a company that has a procurement before USAID. Can I talk to somebody that I knew while I worked there, even if I happen to know that they work on the procurement? Sure, but I can't talk about the procurement, right? I can't bring that up. But it doesn't prevent you from just having basic social interactions with your former colleagues. Okay, so lifetime ban. Now that we've talked about sort of what it means to communicate to or appear before the government, what it means to do so on behalf of someone, and what the intent standard is, then Abby is going to talk about what particular matters are.
Thanks, Sarah. Like you said on the previous slide, particular matters. One, it has to involve a specific party. So that's going to be contracts, cases, claims, investigations, grants, and then the catch-all, other matters focused on identified parties. Um, so in defining a particular matter, it's sometimes easier to define what isn't one, right? So, like a modification of a contract usually isn't going to be a new particular matter because it involves that same specific party. Um, but a follow-on contract, even if it's to the incumbent contractor, likely is going to be a new particular matter because it's a whole new set of facts that even if the specific parties are the same, the whole source selection process that went into that sets it on a new course there for it being a new quote unquote particular matter. So task orders that are issued under an umbrella contract may be interpreted as a separate particular matter if the government determines that articulated lines of division exist between task orders. So, for example, and a lot of my analysis here and my examples focus on contracts just because that's what we deal with most often, and is, I would say, probably 95% of the situations that you would be asking questions about is, when is a different contractor, a type of contract, when is that a new particular matter for purposes of this statute here. But again, just want to reiterate, it's not only contracts that's a particular matter. But so in this example where, say, you have a multiple award blanket purchase agreement that's established, the individual task orders that are issued to different contractors might be viewed as different particular matters, or because they're going to be, different identified parties, assuming that different task orders are issued to different contractors under the blanket purchase agreement. But um, you know the line here is whether articulated lines of division exist. So for like a single award umbrella contract where task orders are issued under it, most likely the task orders there are going to be all viewed as one particular matter. So if you're looking at hiring uh, a program manager, and that program manager in your position at the company would be um, in a government facing position and be making representations back to the government, um, are they banned then from representing back to the government for a a single award like IDIQ that maybe they didn't work on. Maybe they didn't work on issuing the overarching IDIQ, but they did work on the specific task order. Are they banned on making representations back for different task orders? It's so fact specific. Probably in a single award IDIQ instance, they would be, because those task orders would be seen as very interrelated. In a like GSA schedule kind of contract, like task orders that are issued by different agencies under that GSA schedule, most likely that's going to be viewed as an articulated line of division there. So, just because somebody served as a program manager on a task order issued under a GSA schedule for the Navy, that doesn't prohibit them from representing back on, a different contract for the Army, that if both were issued under the GSA schedule. So I know that can be very complicated. Like Sara said at the beginning, a lot of our discussion today is just to kind of give you some context to be able to know, when you should phone a friend here, and know when you should ask more questions. But hopefully that gives you, a good baseline understanding of the interplay between how a particular matter can be defined and the complexities there. And I'll turn it back over to you, Sara.
Great. And then, another part of this test is that you had to have worked on it personally and substantially while you were employed with the federal government. Personally doesn't mean that you were the only person who worked on it. You could have worked on it with as part of a team. And then the substantially is going to be fact specific. We have here some roles that we often see meet the test, but it can be, and it depends situation, right? Like, for example, if you are the COR, at what point did you become the COR in the contract? Were there specific parties identified at that point? Were you someone who just scheduled a meeting for the team? That's not participating personally and substantially. But were you someone who reviewed contract proposals or conducted an investigation or litigated a case on behalf of the government? That's what we're going to see more of meeting that definition of personally and substantially. All right, let's go to the next slide. I see we have about 23 minutes left. Okay, so we talked about the lifetime ban, and the lifetime ban again is on representing back, talking to the government about specific matters that you participated in personally and substantially, and that's the lifetime of the award. There is another provision of 207, this is A2, which has only a 2-year representation back ban. And the elements are similar for what we just talked about, but what does not exist under this provision is the requirement that you have participated personally and substantially in the matter. Under A2, this is about matters that were pending under your official authority. And that can be a subordinate. It can be many levels below you. If you're a very senior employee, it can be all of the work in a work unit that's under you, even if you never yourself look at any document or anything related to a particular matter, right? So let's say I am in a senior role at maybe an office director level in the government, and someone 2 or 3 levels below me is the contracting officer on a particular award. Even if I never saw a document or anything related to that award, and I had no idea what the award was for or who benefited from it, I would still be subject to this 2-year ban, so long as that work was pending under my responsibility during my final year of federal employment. The tricky thing when you're analyzing former subordinates' work is if, as a supervisor, you were in the weeds with your subordinate on a particular matter, you could also be subject to the lifetime ban because you may have participated personally and substantially. So when you're looking at a subordinate issue, don't just assume it's only the 2-year ban. We've got to look at specific facts to see what that employee actually did for the lifetime of their government employment, and specifically what was pending under their official responsibility during their last year of employment. One thing I'll flag about this is there is a knowing element to it. You need to have sort of known that these matters were pending under your official responsibility. But the Office of Government Ethics has made it clear in their regulations that there is some affirmative duty on the part of the former government official to ask questions, right? Like you can't just say, oh, I had no idea what was going on, right? Like if you have some reasonable basis to think that a matter might be impacted by this 2-year ban, you're responsible to go back to the ethics official at your former agency and ask the question and try to get an answer. So again, knowingly doesn't allow you to sort of have your head in the sand. You've still got to do a little bit of research. Okay, next slide, please. Just to revisit again what you can and can't do here. 207, I know I'm a broken record. It's about representing back to the government. You can still do behind the scenes work, and there's a lot that former employees can do behind the scenes. You can draft documents, you can strategize, you can attend internal company meetings. You can go as far as telling your colleague, oh, the key person at such and such agency that you want to know is Abby, and Abby's favorite color is purple, and Abby goes to, insert local coffee shop every Monday at 3 p.m., right? Like you can share that level of detail with your internal coworkers. You can help strategize, but you cannot sign your name to documents, proposals, things like that are going to the government. That would be a representation back. You can't attend meetings with the government. You cannot attend phone calls with the government. You can't email the government about these issues. You have to focus on behind the scenes activities. And again, when you're focusing on behind the scenes activities, you cannot share any kind of procurement sensitive classified type information. Abby, do you want to flag the business development activities matter here?
Yeah, I think we'll be talking about that on a later slide when we talk about the covenant against contingent fees. So I think one thing I do want to flag on this past slide where Sara was talking about all of the permissible versus impermissible activities, that was a breakdown of, if A1 or A2 applies and a representation back ban, either lifetime or 2-year, based on whether the employee themselves was personally and substantially involved or whether it was under their responsibility as a supervisor. But those permissible activities are assuming you've gone through that whole analysis and somebody you've just hired has that representation back ban. There's still so much they can do for you there. And even before you hire somebody, if you're coming, which ideally you would be coming to these realizations right before somebody's on your payroll, and you would know kind of what they can and can't do. But there's so much that former employees who have a representation back ban, either lifetime or, for that 2-year period, there's still so much they can do for you. And we'll touch on that business development piece in a little bit here.
Great. Yeah, thanks for that clarification, Abby. And then the last provision under 207, we're just going to hit briefly. This is about senior employees. So for certain former government employees whose salary was at a particular level, they cannot talk to their specific agency that they worked at for 1 year with an intent to influence, right? And this is really broad. And this is the one that is for the shortest period of time, right? It's only 1 year, but it's the most broad because it's about things that you might have never touched or known about during your government employment. It's also about things that might not have been known to or worked on by any of your subordinates. So just by nature of being at a certain pay level when you were with the government, you cannot represent back with an intent to influence to the agency where you worked for 1 year. We don't see this one as much, but just wanted to flag it. Next slide. Great. And then I already talked a little bit about the penalties, but violating 18 USC 207, it's a big deal, right? There's criminal penalties, there's potentially jail time, there's huge potential financial penalties. And, even though these consequences here that I'm talking about under 207 are really focused on the former government employee themselves, if you're the contracting company or the NGO or whatever that hired that person and they're found to have violated the law, there's still going to be impacts for you, right? There's still potential impact to your business reputation. And Abby's going to speak to this from more of a contract lens.
Yeah, absolutely. So we really want to flag this FAR clause for you guys. So FAR 52203-13, it's called the Contractor Code of Business Ethics. So this FAR clause should be inserted into every contract that is above, currently right now the threshold is 7.5 million and greater than 120 days period of performance. So, for most contractors, like, this FAR clause is going to be present in most of your contracts. And there is an exception for some of the requirements in that FAR clause for small business concerns. We're not going to get too in the weeds of that in parsing out, what is and isn't required under this FAR clause for large businesses versus small businesses, but just wanted to flag that up front. For you to review if you're a small business concern and you think you need to buff up your contractor code of business ethics. Not all of it may be applicable to you. But one thing that is applicable to both large business concerns and small business concerns is this mandatory disclosure rule that's wrapped up into this contractor code of business ethics. So at base, 52203-13, requires contractors to have some sort of, and it's in the title, code of business ethics. But then wrapped up into that is this mandatory disclosure piece. So if the contractor discovers that one of its employees, or not even discovers, but just has credible evidence is the standard in the FAR clause, that either a principal, employee, agent, or subcontractor, so pretty broad prohibition there, has committed a violation of a federal criminal law involving fraud, conflict of interest, bribery, or gratuity violations found in Title 18. So that's that whole Section 207 that Sara and I have been talking about is applicable there. So if you have any credible evidence of a violation there, you as the contractor are required to disclose this evidence to both the Office of the Inspector General for the agency that the contract is issued under, as well as the contracting officer for that contract. And so, I think that the mandatory disclosure piece of 52203-13 is really the why you should care aspect of Section 207, because like Sara said, there's reputational harm, that can happen for your company. Really, it's the criminal and civil penalties for a former employee. But if you don't timely disclose, credible evidence of a violation of one of your employees here, that's grounds for an investigation by the OIG. That's grounds for termination for convenience, possibly termination for default, possibly suspension and debarment, right? If there's a discovery of, that you as the contractor discovered this information and then tried to bury it rather than report it. So, you know, there's a lot of different ways that this can impact you as the contractor, even though 18 USC 207, you know, penalties are specific to the employee.
Great.
And I
Thanks,
know
Abby.
we're coming up
We're
on
at
close to
on
time,
time.
so yeah, let's see if we can go through these next few slides
Okay,
quickly so that we can get to the
great.
fun stuff, our hypotheticals.
So on this slide, I just want to flag that even if you are a sole proprietor, LLC, or something like that, that can still be representing back to the government on behalf of someone. Um, Also, when we're talking about the representation back ban, it is about the matter. It is not the agency where the matter was located, as long as you're not a senior government employee. So we've gotten some questions as federal agencies have shrunk in the last year and some of their procurements have gone to other agencies. These laws still come into play, so it's important to be aware of those. On the next slide, we're just flagging that for current federal employees, their ability to talk to other federal agencies, including the one that they work at too, is incredibly limited. This is also a criminal statute. And so if you have someone working for you who is on, you know, DOD terminal leave or administrative leave or something like that, their ability to talk to the government about anything is incredibly limited. So if you happen to have some kind of an employment or, you know, independent contractor relationship with a current government employee that's doing work for you, make sure that there's no issues here. Next slide. Uh, and then just flagging a couple of other considerations. Some federal agencies have their own ethics regulations. And so when you're hiring someone or when you have a former government employee working for you, it's important to know not just the federal laws, but they should also be familiar with their own agency restrictions, and we can help you with that as well. 18 USC 203 impacts current federal employees' ability to receive compensation related to matters that are before the government. We don't see that very often, but just flagging that it's out there. Abby, anything you want to mention on this slide?
Yeah, I'll quickly go over, I know I said earlier when we would touch on business development later. So there is a FAR clause that you should be aware of, 52203-5, which establishes a covenant against contingent fees. And, you know, just like everything, it's such a fact-specific analysis, but I think a broad way that we can phrase the prohibition is that contractors are prohibited from hiring consultants on a commission-based payment structure for business development kind of roles. So there's this covenant essentially against paying commission-based structures, but there's exceptions to that. So a bona fide employee is an exception to that. So if you wanted to hire, you know, a former government employee, put them on your payroll, and they're a full-time employee that is, you know, fully under your control as the employer. They're not just somebody who's putting in 10 hours a day, or 10, sorry, that would be great if they were putting in 10 hours a day on business development. 10 hours a week, um, that kind of structure is going to be prohibited under 52203-5, but a bona fide employee can be paid on a commission-based structure. And then I'll quickly touch on FAR Part 3, personal conflicts of interest. This is separate from FAR Part 9, which is going to be, you know, different conflicts of interest that you as the contractor might have based on your specific roles on different contracts. FAR Part 3 really has to do with impropriety between government and contractor relationships. And the important thing to note here is that this FAR clause prohibits even the appearance of impropriety. So if there's any, you know, sketchy overlap between when somebody was hired, you know, whether they were serving personally and substantially on a source selection board, and then hired soon after award was made to that awardee, that's going to raise some flags regarding the appearance of impropriety here. And the good news is that at both GAO and the Court of Federal Claims, you can't just claim appearance of impropriety and then, that's the end of the inquiry. There has to be hard facts to support the appearance of impropriety. And the hard facts means that, you don't have to show that there actually was any impropriety, but you have to show that there was like the ability for improper actions to have happened. So again, this is really about kind of close personal relationships. It's about some hazy timeline overlap kind of things. And it can be incredibly fact specific in the case law there in determining what an appearance of impropriety actually is. We could probably host a whole nother webinar just dealing with that. So next, we will kind of go through some scenarios that we put together to talk about, is there anyone you can't hire? What roles can certain former government employees play in my company? And then what to do if you discovered that you or one of your employees or subcontractors is in violation of one of these regulations. So let's go to scenario 1.
Okay, you contract with a former HHS employee as an independent contractor. You are bidding on a follow-on award for a contract where the former HHS employee was the COR. You are the incumbent, and the current contract is valued at $15 million. So the first question is, can this former HHS employee talk to the CO at HHS about the requirements for the follow-on award? Can we do a thumbs up or a thumbs down? Thumbs down. Yeah, so probably not, right? So we don't exactly know what tasks the COR performed on this particular award while they were with the government, but if they participated personally and substantially on the matter while they were employed by the government, that 18 USC 207 ban is going to come into effect. Abby?
Yeah, so are you allowed to pay him for his work? And you can give us a thumbs up, thumbs down on this one. Again, think back to those Procurement Integrity Act slides at the beginning. I'm seeing a mix here, thumbs up and thumbs down. Okay, so the answer here, probably. So the right questions to ask are, you see that $15 million amount, right? So that's over that $10 million threshold. So in that instance, perhaps not. You're not allowed to pay him for his work. However, you don't know when his separation date was. So, we need more facts here. Are we within the year time period? If he served if he was a former HHS employee and his, date of separation was 3 years ago, certainly you can pay him for his work because he's outside of that year timeline. And then the other important thing here is that he was the core. So he doesn't fall into one of those like blanket prohibition positions that's at 41 USC 2104 1 or 2. But as the core, he possibly could have made certain decisions that are prohibited under 3 of that section there. So this is one where you as the contractor, you have to look at it and say, I need more facts here to be able to make that determination. And then what if he didn't disclose he was the core for the award at the time of hire? So does this raise any concerns under Section 207? Has the core represented back to the government on matters he worked on? Particular matters that he worked on that were under his responsibility or that he personally and substantially participated in. You don't know any of this yet, so you're not sure. So this would be the piece of the mandatory disclosure piece of the Contractor Code of Business Ethics FAR clause that you would have to be digging for credible evidence at this point. You're not sure if you have to make a mandatory disclosure yet, but the fact that he didn't disclose he was the core probably raises some red flags for you, and you should certainly conduct an investigation.
And in addition to potentially needing to make a disclosure to the government, if you find that one of your employees violated one of these rules, putting my employment lawyer hat on, you also might have a misconduct issue that you need to deal with. So you want to think through what your handbook says about dealing with those kinds of issues as well. Abby, why don't we skip to scenario 3, since I think we only might have time for one more. Thanks,
All
Abby.
right, perfect. And then, if you have to go, we fully understand, but we're going to go through at least scenario 3 and maybe one more. So a contracting officer at the Navy independently reaches out to inform, you as the contractor that she's looking to make the jump to the private sector. You've never bid on any proposals issued by her. Don't have any active contracts where she is serving as your contracting officer. You go through the interview process, you make her an offer, and you give her 2 weeks to accept. The next day, she issues an RFP, which your team wants to submit a proposal for. So, what are your next steps here? This takes us back to that current employee piece of the Procurement Integrity Act. So at the time you made her an offer, there weren't any red flags for you, right? You went through that whole analysis of the fact that she's not currently serving as a contracting officer for you. You've never bid on any proposals where she was named contracting officer, so there should be no conflict there. However, because you want to bid on this RFP, we would recommend reaching out to the employee to ask her to follow those procedures there, in which she promptly reports the employment offer to both her agency ethics official as well as her supervisor, and then either disqualifies himself or herself or rejects the possibility of non-federal employment. Because you gave her 2 weeks to accept, and within those 2 weeks she issued the RFP, most likely nothing would have happened in those 2 weeks for her to have personally and substantially necessarily participated in the procurement, to which you're now an offeror. But as the contracting officer, she could have been involved in requirements developing. She could have been involved in those pre-planning stages that would trigger her having been personally and substantially involved in that. You just don't know at this point. So do the due diligence on your end to make sure that she, as the employee, is following what she has to do. And then you have the record there that, you've reached out to her and requested that she do this. And then, she either recuses herself from the source selection, or she rejects the employment. Um, or at that point, she could accept the employment and terminate her position with the government as well. So I believe, yeah, we've covered both of those questions there regarding your next steps. And then the original offer was not in violation of any of the prohibitions because, at that point, she had not been a contracting officer in anything that, you had been awarded or had participated in. Sarah, I don't know, do we want to go through?
Should we maybe do the compliance tips?
Yeah, let's do compliance tips.
Okay.
There we go. And then
Great.
we will sign off.
So we know many of you are government contractors. There are certainly things that our employees do that we can't control, but what we can control is having a robust ethics policy and making sure that every employee gets a copy, they sign acknowledging receipt. You give them an opportunity to review the policy, to ask questions, to understand it. It's also important that you have a process to identify potential conflicts early. Abby mentioned a bunch of rules that can be violated just when you're first starting to discuss employment with someone. So it's really important to make sure that you understand who's applying for your job, who you're interviewing, what their potential conflicts might be, and that you start from the early pre-hiring phase to address these potential conflicts. If you identify particular conflicts, we can help. We help clients all the time with firewall agreements, mitigation plans, clear written orders to the employees about what duties they can and can't do, the time periods for which they might have any kind of restrictions that are impacted for any of these rules. It's also really important that you know your contracts, right? You know what your contracts require, you know if they have any mandatory disclosure rules, so that if you do find out that one or more of these ethics laws was violated, that you timely report. We tend to see that failure to report is definitely a fact that will weigh against your company in terms of the government making decisions in terms of penalties. You know, if you know about something and you don't report it as required. Abby, anything to add here?
No, I think you covered it all, Sarah. I did note there was one question. I don't know if Courtney is still here, but she asked whether a former government employee, say a computer programmer, that now works for a company that has a contract to do the same work that the employee used to perform for the government, can they attend meetings with the government about work priorities and assignments? They may have to answer questions about the status of the work. Is this considered representing back? And then I'll add the caveat with an intent to influence. So I think that's a really interesting question. They're not prohibited from performing that same work by any means, and that kind of back and forth happens all the time. Whether they can attend meetings with the government about work priorities and assignments, possibly. This is definitely a gray area one, Sarah, and I don't know if you have any thoughts about this, but you know, answering questions about the status of their work, that's pretty fact specific. That's may not be viewed as intent to influence, but you know, if we're looking at like timeline slips in a project and this person is in the meeting and they're saying, you know, they're maybe speaking on behalf of a few programmers to say, this is where we are. It's because of, you know, X action by the government or inaction by the government that has resulted in this timeline shift and shifting priorities. And that's the reason that our timeline has shifted and things are delayed. That probably could, I would view that at least as intent to influence, because that can have impacts on, you know, how the government, you know, pays out certain CLINs or how, whether, you know, whether the government decides to push back any deadlines or anything like that. So that could certainly have intent to influence flavor. So I would recommend against something like that, or putting your computer programmer in that situation. But you know, that's only if in that instance they're working on the exact same contract that they were personally and substantially involved in. You know, they could be a computer programmer for the same agency that's on a different contract, and then there wouldn't be any issues at all. And I know, Sarah, I kind of took over that one. So if you have anything to add, please do so.
No, you did great.
Okay, Courtney, I hope you were still here. Sorry we didn't see your question until after. But thank you so much for everyone for attending our webinar today. And I know we're going to send the slides out, or not the slides, but we're going to send out a recording of the webinar after. So you should get that. Yeah, and thank you everyone. We appreciate your time today.
Yep. Thank you so much.